This podcast uses AI-generated content. All information is for general purposes only and does not constitute financial, investment, legal, or regulatory advice. Listeners should verify information independently and consult qualified professionals for personalized guidance. Welcome to the Luxembourg Intelligence News Briefing Weekly, your trusted source for developments in one of Europe's most dynamic and well-regulated hubs. Today, we're taking a deep dive into how Luxembourg's financial and legal landscape is, strategically reshaping itself.
That's right. It's quite a precise evolution, really, driven by three key forces that are actually quite interconnected.
Which are the great data convergence, harmonization's final mile, and something new, judicial assertion.
Exactly. And understanding these isn't just, an academic exercise.
No, it's crucial for anyone navigating operations, compliance, even strategy here.
Absolutely. What's fascinating is how these different pillars work together. They synergize to build a more robust, more responsive legal framework overall.
So we'll explore how these changes aim to elevate workflows, refine documentation, and sharpen those all-important risk management strategies.
Precisely. It's about enhancing the entire ecosystem.
Okay, let's start with the first theme, the great data convergence. This sounds like a big shift from just reacting to things towards being more proactive using data. How is that actually happening?
Well, it starts with a pretty significant overhaul of two key registers, the Luxembourg Trade and Companies Register, the RCS, and the Register of Beneficial Owners, the RBO.
Okay.
New legislation came in early 2025. There's a transition period ending August 1st this year, and it gives the Luxembourg business registers, the LBR, new tools.
Tools for what exactly?
For ensuring data consistency, for proactive monitoring, and crucially, the power to impose sanctions if things aren't right.
And this affects everyone.
Pretty much. Any entity registered with the RCS or the RBO needs to be aware.
So beyond the mechanics, why is this convergence so important for, say, finance and legal professionals, for you listening?
Because this better data infrastructure directly empowers the regulators. Think of the CSSF, the Commission de Surveillance du Secteur Financier, and the AED, the Administration d'Enregistrement des Domaines et de la TVA.
Right.
Their supervisory mandates get stronger. For example, the AED expanded its AML-CFT reporting, that's anti-money laundering and countering the financing of terrorism reporting. It now covers all unregulated alternative investment funds, not just the RAFs, the regulated alternative investment funds. This started back in February 2025 with a deadline of June 30th.
And this uses the improved central data.
Precisely. It demonstrates Luxembourg being proactive, reinforcing stability and integrity. It's a strategic move using data as a risk tool.
It sounds like it increases the burden, though.
Yeah.
Higher costs, maybe more liability.
It does translate to higher operational costs, yes. And that really underscores why having skilled legal counsel is no longer just a good idea. It's essential. They help turn that compliance burden into, a strategic advantage through robust risk assessment and meticulous documentation.
That leads us nicely into the second theme, harmonization's final mile, taking EU rules and making them real, on-the-ground market practice. Let's start with digital assets and MiCA.
Right, MiCA, the Markets and Crypto Assets Regulation. Luxembourg's embracing digital assets, but with a very robust framework.
How so?
Well, a key moment was July 17th, just this year, 2025. NextBlock Ventures launched an alternative investment fund, an AIF focused entirely on blockchain and crypto.
It's interesting.
And importantly, it's managed by an alternative investment fund manager, an AIFM, that's fully authorized by the CSSF. That signals real maturation in the space, institutional grade.
And this follows new laws implementing MiCA.
Yes, legislation from early 2025. It also gave the CSSF stronger powers, including the ability to levy fines up to 15 million euros.
15 million, wow.
It's a calculated move. Foster growth, yes, but within a meticulously regulated, innovative environment.
Okay, what about broader fund reporting, especially for alternatives?
The CSSF published Circular 25/894 back in June. It repeals the older Circular 15/612.
It looks new.
The mandate is broader. It applies to all Luxembourg investment fund managers, IFMs, when they manage unauthorized AIFs. Think of things like an SCSP, a Société en Commandité Spéciale.
So even if the fund itself isn't directly CSSF authorized?
Correct. The aim is to give the CSSF a complete, up-to-date picture of the entire alternative investment scene. There's a slight nuance in timing, too.
Go on.
Authorized AIFMs must notify the CSSF before they start managing such a fund. Registered AIMs have to do it no later than 10 working days after they start.
Got it. Now, corporate restructuring, the EU Mobility Directive, has been a hot topic.
Indeed, it has. The law transposing it came into effect April 1st, 2025. It introduces what's called a special regime for EU cross-border mergers, demergers, and conversions involving specific company types, SA, SARL, and SCA companies.
And what does this special regime do?
It significantly boosts protections. For shareholders, you get statutory exit rights, ways to challenge cash compensation. For creditors, there are provisions for additional security.
And employees?
They get detailed reports and stronger participation rights. And critically, notaries now have a bigger role.
How so?
They perform substantive checks on legality and look for potential abuse. They're essentially key gatekeepers now.
So more checks mean potential delays, financial uncertainty.
It can mean that, yes. Deals face an extra layer of quite rigorous scrutiny. Preparation has to be meticulous. But there's an upside.
Which is?
This positions Luxembourg as a leader in, let's say, governance-first cross-border deals. It could attract sophisticated capital that values that legal security over just speed.
Makes sense.
Okay.
Finally, under harmonization, banking and payments, the verification of payee system, VOP. Sounds like a fraud fighter.
It absolutely is. It becomes fully operational for all Euro credit transfers from October 9th, 2025. It's mandated by the EU's instant payments regulation.
And how does it work, simply put?
Before a payment goes through, the system checks if the beneficiary's name matches the name linked to their IBAN, their international bank account number.
Okay.
It gives you a status, match, close match, no match, or maybe verification not possible.
What if it's no match, but you send it anyway?
Then you, the user, assume responsibility if something goes wrong. There is, however, an important detail for businesses doing lots of payments.
But opt out.
Exactly. An opt-out is available for file-based bulk transfers, but this raises questions about liability for corporate clients who choose that option.
So significant operational changes needed there too.
Definitely. And again, this is where sharp legal advice on navigating those liability shifts becomes indispensable.
Right. That brings us to our third theme, judicial assertion. Court rulings are refining how enforcement works and defining rights more clearly. Let's talk about the non-Bison item case.
Yes, this was a key ruling from the Luxembourg Court of Appeal on February 26, 2025.
What happened?
The court ruled that criminal proceedings against a financial institution couldn't go ahead because the CSSF had already imposed a final administrative sanction for the exact same facts.
Non-Bison item can't be punished twice for the same thing.
Precisely. It aligns with principles from the European Court of Human Rights. It forces greater coordination between the CSSF and the public prosecutor.
Does it weaken enforcement?
Not really. It incentivizes cooperation during the administrative phase. It refines the process, making it more disciplined and rights-respecting, rather than weakening the AML-CFT framework itself.
And speaking of the European Court of Human Rights, the ECHR, they also had something to say about asset freezing.
They did. Back in October 2024, in a case called Amerisoc Center SRL v. Luxembourg.
And the finding?
A violation of property rights. Why? Because there wasn't an effective way to actually challenge the asset freezing order.
So even legitimate actions against financial crime need checks and balances.
Absolutely. It underlines that fighting financial crime must be balanced with fundamental procedural rights. For banks and other institutions, this really impacts how they handle freezing orders and the related agreements. Due process must be available.
So these rulings aren't necessarily making things easier, but perhaps clearer, more defined.
Exactly. They signal a maturing regulatory environment. Robust enforcement is now, intrinsically linked with fundamental rights protection. It's not about weakening the fight against financial crime. It's a sophisticated refinement. It pushes institutions to embed human rights considerations right into their compliance DNA.
And it shows Luxembourg continuing to be proactive, evolving its governance to balance effective oversight with protecting rights.
That's a good way to put it. Continuous refinement.
So wrapping this up, what does it all mean for you, our listener? Luxembourg isn't just reacting, it's actively, meticulously shaping its future.
Leveraging data, integrating EU rules, refining judicial oversight.
The challenge, and maybe the opportunity, is to see these shifts not just as separate burdens, but as connected parts of a more sophisticated, resilient, maybe even elegantly governed financial ecosystem.
I think that's fair to say. An elegantly governed ecosystem.
Thank you for tuning in. We trust you found this briefing insightful. Until next time, stay informed and ahead of the curve. Hit subscribe, like.
This podcast uses AI-generated content. All information is for general purposes only and does not constitute financial, investment, legal, or regulatory advice. Listeners should verify information independently and consult qualified professionals for personalized guidance.
Luxembourg Intelligence News Briefing.